Hello, everyone, and welcome to today's ITIF event, The State of State Privacy. In the absence of a federal privacy law, 19 states and counting have passed their own comprehensive data privacy legislation. As more states move forward with distinct approaches to consumer rights, enforcement mechanisms, and compliance obligations, policymakers face growing questions about how this expanding patchwork shapes the prospects for federal action and how it affects everyday Americans and businesses of all sizes. Will these diverging state models increase pressure on Congress to act, or will it make it harder for Congress to reach a consensus on a single federal standard? If Congress does remain gridlocked, what does the future of US privacy policy look like? As Congress and state legislatures turn their attention to related issues like AI and children's online safety, will these other patchworks continue to emerge? And as someone who first covered this issue for ITIF in 2019, will I still be talking about it another 7 years from now? My name is Ash Johnson, and I'm a Senior Policy Manager for the Information Technology and Innovation Foundation, ITIF. Very quickly, I'd like to welcome our audience online. We'll be taking audience questions at the end of the hour, but feel free to submit your questions throughout the event. Wherever you're watching, you can follow the link to Slido in the description to submit your questions. And don't forget to subscribe to our YouTube channel and turn on notifications if that's where you're watching. Joining me today to talk about state privacy laws, I have Deborah Collier, Vice President of Policy and Government Affairs at Citizens Against Government Waste, a nonprofit devoted to eliminating government waste, mismanagement, and inefficiency at all levels. Jake Morabito, Senior Director of Policy at the American Legislative Exchange Council, a membership organization of state legislators dedicated to the principles of limited government, free markets, and federalism. And Morgan Stevens, Policy Associate at ACT, the App Association, a global trade association for small and medium-sized technology companies. Thank you, all three of you, for joining me today. Really excited to have this conversation. I wanted to start by opening with how this debate has been affecting you in your work and your organization's mission. And I'll start with Deb.
Thank you, Ash, and thank you for having me here today. Citizens Against Government Waste looks at regulations and laws in a comprehensive way. The regulations can create burdens or they can help improve how we operate. In the instance of consumer data privacy, having states regulate what is essentially interstate commerce, which is data that flows over the internet, it kind of creates barriers to small businesses. It creates confusion for consumers. It really bogs down for particularly small businesses. I see Morgan nodding alongside me for small developers who are trying to build something that will benefit society when they have to navigate 19, 20 or more separate laws on consumer data privacy. So having these barriers put in place really discourages investment, it discourages innovation, it discourages reaching out to what potentially could be consumers in another state from where they are, just simply because they have to figure out what those state laws are. So, this is an interstate commerce issue, and that's one of the reasons why CAGW has been actively engaged in it.
Jake, how about you and Alec?
No, thanks for having me on. And ALEC is a membership organization of state legislators, like you mentioned. We are also a 53-year-old organization. So we've been around the entirety of the internet from 1996 onward. And ALEC put out a publication on consumer privacy, I want to say in the middle 2010s, and cautioning about some of what California was trying to set up back then, mimicking GDPR. And if you look back at that publication, a lot of those findings have come to bear, unfortunately. And Something that I fear is just the longer this goes on, right? I've been working in public policy the better part of 12 years now, and we were talking about it back then. We're still talking about it now. That the longer this goes on, I feel like the prospects are getting dimmer as far as I hate to be a downer to start this podcast, but there are some larger conversations happening about AI and kid safety, like you're mentioning, Ash. But data privacy to me seems like a prerequisite to a lot of those conversations. So we shouldn't lose sight of that. I know we got close a couple years ago under Chairwoman Kathy McMorris Rogers. So hopefully we can capture some of that energy and get this done. States, some are doing better than others. I'm happy to share some of what ALEC members and ALEC legislators are working on in that respect.
And then finally, Morgan, how about you and ACT's work?
Yeah, thank you. And many thanks to ITIF for hosting this event. ACT represents small and medium-sized developers who drive innovation and create the apps, tools, and digital experiences that consumers rely on every single day. They don't have the kinds of legal teams that larger businesses have, so keeping up with this patchwork of state privacy requirements, which all have their own slightly different definitions, thresholds, consumer rights, and compliance obligations, it could be incredibly resource intensive. So that often means foregoing entering new markets or shelving new products or not hiring new employees in order to spend resources on implementing and interpreting dozens of different regulatory regimes. And while it's true that state laws tend to carve out small businesses, that doesn't mean that they are completely exempt from obligations. In fact, last year we saw amendments in Connecticut and Montana that lowered the applicability threshold and pulled in more small businesses who now have to kind of watch over their shoulder for that to happen again in other different states. So this uncertainty and regulatory fragmentation is a direct tax on innovation, which is why it is so important for Congress to pass a federal preemptive law.
Thank you, all three of you. I kind of want to start this conversation chronologically. Jake mentioned California, the first state to enact its own comprehensive privacy law. How has that kickstarted and since then it continued to impact these privacy debates happening across the country in these 19 states and counting? Jake, if you want to get started.
Happy to do that. So, like you mentioned, California kind of got things started, and then the good news is pretty shortly thereafter, kind of a few years thereafter, some more states like Virginia and Utah came along with some more sensible approach to privacy, in my opinion. And ALEC members, part of what our members do is we develop model legislation or statements of principle to help if you're a state elected official and you're looking for a solution rooted in our principles of limited government, free markets, and federalism. ALEC and our state legislative members have worked to develop those solutions. So actually, back again around 2019-ish, ALEC developed two pieces of model legislation. One are some basic principles on privacy. Some of them are pretty basic and things that we're used to working with in this space. Essentially, the private sector should be leading here. Government should avoid any kind of undue restrictions on the economy and respecting the internet operating as a inherently cross-jurisdictional technology. The marketplace is also working. So, so some platforms and services have market themselves as very privacy centric. Some services like Signal or DuckDuckGo, go out of their way to highlight that as a competitive advantage, and that's a great thing we should be encouraging. And then individuals should also be in charge of their own privacy choices. So while it might be well intentioned, what some of these states are trying to do by making that decision for them, it should be the individuals making that call at the end of the day. And then the second thing that ALEC did, which might seem antithetical if you think of ALEC as a state organization, is our members actually adopted a resolution specifically embracing a single federal standard for consumer privacy. And why would they do that? While states, are laboratories of democracy, and there's a lot of good innovation there on things like technology and especially AI. I mentioned data privacy and consumer privacy in particular as the prerequisite. And it's important that that's a uniform national standard so that we, especially in a tri-state area like the DC area, that you don't have residents of one county in Maryland having one set of protections and standards, and then across the river, you have a different set of standards for Virginia. So that's the opinion of ALEC legislators. And the good news is lots of states have taken up that Virginia approach. Hopefully we can head more in that direction for the federal conversation.
Absolutely. Deb, how about your experience since California passed its privacy law?
Well, the California law kind of got the whole ball rolling with states going Congress isn't doing this job. We've got to do it for them. However, when you've got, I think it's now 20 different states, we had 3 laws that just went into effect in January. When you've got that many states with varying different laws, it's really a difficult thing for folks to navigate. California has had to amend its law several times because it was so burdensome that companies just couldn't comply with it. So they had to redo it and redraw the map and again and again. And that's not a situation that's good for any state to be in. I think having a national framework will provide that consistency that companies need. And preempting state laws, Congress could even actually look at some of the better privacy laws that have been enacted in the states. Take a look at things like what ALEC has done with their model legislation. What's in those bills that make them good privacy laws, and perhaps incorporate those into the national framework? But having to, for anybody having to deal with 20 plus, who knows where we're going to be 5 years from now, 30 plus, 40 plus, maybe every state's going to have its own privacy regs. That's going to be really difficult for not just innovation, but also the economy as a whole, just simply because the cost of complying with 50 different, up to 50 different state privacy rules is really going to be a burden to anybody in business. And we know that businesses, especially small businesses, are the drivers for this economy.
Morgan, do you want to especially build on that point from ACT's perspective?
Absolutely. Yeah, to echo both Deb and Jake, small businesses want to protect their consumers' privacy. No small business wakes up in the morning and is like, you know what I want to do today? Actually, I want to just completely get rid of privacy, and not have that for my consumers. They want to do so. They want to help protect their consumers' privacy, and one set of rules will help make that happen. Which is why, Congress needs to pass this law so that way they're not having to navigate many oftentimes conflicting state privacy laws. That way they can complete that goal a little bit easier, and then make it so that way they can also just focus on serving their customers and building new products and innovating more.
Yeah, definitely. Jake, you kind of touched on this a little bit in your comments, but I'd love to hear you expand on it. Kind of the trends that have emerged among state privacy laws when it comes to which states have been passing them, who's been considering them. And you mentioned kind of different model legislation, essentially, that kind of other states have been looking to as inspiration.
Yes. So I think you mentioned at the top somewhere around 19, 20-ish states have what we call comprehensive privacy laws on the books. So those, there are some more sectoral focused laws out there when it comes to things like healthcare or breach notification. Or again, people point to Illinois' biometric law. I think Texas has a biometric law. So I think we're primarily today talking about the comprehensive consumer data privacy laws. So like I mentioned, and Deb was mentioning California kind of having fits and starts, and I know they had, I think, a ballot initiative, right, that kind of set up their privacy office. So there's been a lot of activity in California, but the bulk of the states have pursued this alternative notice and consent model that Virginia and some other states picked up. I think there's about 7 or so states this session that are working on privacy right now and might get some of that through the finish line. Something I have observed as far as trends is that you did have, I believe it was Maryland a year or two ago, pursued a different approach, focusing more on data minimization and again, diverging a little more from this other model that states were picking up. And I think absent a federal solution, you want a lot of these state bills to harmonize for the reasons that Deb mentioned, as far as ease of compliance and again, actually meaningfully providing protection to users at the end of the day, making sure that startups and newer entrants to the ecosystem aren't bogged down in compliance regulations or spending millions of dollars on attorneys to double check the requirements in 20 different states. Ultimately, and the incumbents do have the deep pockets to afford those legal fees, but The small innovators don't have access to that. So something, and then I've seen that several New England states, I believe Maine, Massachusetts, and some others are kind of trying to follow that Maryland footprint. So we talk a lot about a patchwork, but you might even get to a point where this becomes kind of mutually exclusive, where complying with one may not result in compliance in another. Instead of that kind of race to the top, the like I'll just comply with the strictest one and then I'm covered across the states. That may no longer be an option depending on how this goes, which is why it's so imperative that Congress steps in and why that preemption piece is necessary. Because if we, if the national piece is contingent on, if it functions more like a floor rather than a ceiling, that's not going to solve that concern.
Yeah, Deb, I see you nodding if you want to add your 2 cents.
Yeah, it's like Jake said, when states are putting in their own set of rules, they're creating barriers to innovation. A small business doesn't want to necessarily stay small forever. They might want to grow, but in order to grow, they have to have the resources to do that. And they can't afford the attorney fees to comply with 20 or more different state laws when it is interstate commerce that they're doing. Anything that's over the internet has to be considered interstate commerce. And that's one of the reasons why we really do need one comprehensive standard that everybody can follow, a consistent set of rules that will enable companies to understand what their obligations are and to comply with those obligations while growing their businesses.
Yeah, Morgan, that seems like a point right up your alley if you want to add on.
Yeah, so we've seen, a lot of laws kind of follow one of a few different structures, the Virginia model, et cetera. And again, some of this is great. There are some good provisions in these laws that Congress should replicate in a federal law. But every once in a while, we do see a state like the recent comprehensive bill in New Mexico that seems to introduce an entirely new framework. It remains entirely possible that states will continue to introduce new styles, frameworks, and their own quirks, especially as they each try and protect more privacy than their neighbors or the other similarly situated states, which would introduce just a ton of wrinkles for small businesses to navigate, and again just pull resources away from hiring and growth and innovation and a lot more.
Yeah, definitely. And I can speak to, I think Jake was the one who made this point earlier. I know a lot of us here in the policy world live in the DMV area. As someone who has moved back and forth between Maryland and Virginia my whole life, I would love to have the same rights in both states. Kind of moving further into how this impacts American businesses and, like I just said, consumers. Morgan, can you talk about sort of the specific barriers to innovation that this creates or other hurdles that this creates for businesses and their customers?
Yeah, so small businesses who operate nationally have to track and comply with almost 24 different state requirements, and we might see 3 more added on in Oklahoma, Alabama, and Maine here in the next few weeks. In addition to, and that's in addition to new amendments, the wave of enforcement actions that we saw last year, and the potential for more state laws. And this drains resources away from other ventures, again, such as job creation, innovation, product development, and just basic customer service, serving your consumers and building what they want to have and see. And this also hurts consumers who may have different privacy rights, as y'all have said. I've lived in California, Texas, Arizona, and spent some time in Kentucky, and my rights would have differed or just completely disappeared depending on my zip code, which is not a great model to follow for consumer protection.
Deb, can you add to that from CAGW's perspective? Especially, obviously the work of your organization is directly relevant to us all as, American taxpayers. So I'm sure you've got some opinions on the impact on consumers and businesses.
Oh, I do. No, it's this is one of those things where, and it's like Morgan said, when you live in different zip codes, as a consumer or as a citizen, you don't know when you move what protections you take with you. So say you're living in Ohio, you have certain protections under the laws in Ohio, but then you move to, across the river to West Virginia or to Kentucky, those same laws may not provide you protection anymore because there's that inconsistency in the laws. And it holds true for a lot of different areas that, what we call border areas like Cincinnati or Louisville, Kentucky, those areas are very, flexible when you move. You can have a job in Kentucky and live in Cincinnati. When you're working, are you protected by one set of rules because you're in that state, or do your home residents in Cincinnati, do those laws apply? Having consistency when, especially with in the laws, really provides a certainty for consumers as to their rights and their protections. And having those protections in place sets the stage for them to, do other things and focus on, if they're in business, building their business, if they're a consumer, their shopping activity. How is that being protected if there's a state by state approach? So it's just getting rid of the uncertainty is what I think is really critical here.
Jake, can I kind of ask how ALEC's members and the different state legislators that you work with, how are they thinking about this from kind of a business and consumer perspective?
Yeah, it's a great point, and something that I've observed is a lot of times, not only with privacy, but some of these other tech bills, they're framed as, combating big tech or, pushing back against big tech. But oftentimes it is normal, quote unquote, or retail businesses or mom and pop businesses that are most directly impacted by this. I think a good example was, I think this was a year or two ago when Maine was considering a privacy bill that was particularly onerous. It wasn't necessarily Google or Amazon or Meta that helped persuade the lawmakers. They heard from the largest employer in Maine, which is LL Bean, an outdoor retailer in Maine, and they submitted testimony that essentially cautioned, "Hey, this is really going to disrupt our business model. It's going to this." And so essentially, when the largest employer in your state talks, legislators listen. And I think another example too comes with some of these enforcement actions that Morgan was alluding to. I think it was in California. I think one of the earliest enforcement actions wasn't against one of the tech companies, because it was against Sephora, the makeup provider. So not only not a United States company, but an interstate company, or international company. So it's funny that's it's just interesting. I think that those are kind of the more directly impacted in some cases than some of the larger technology companies.
Yeah, definitely. I think that is a point that gets lost in this debate pretty frequently is this impacts a lot more businesses than just tech companies. A lot of the debate centers around quote unquote big tech, but privacy is a much broader issue than that. Morgan, how would a federal privacy law, especially one that preempts state laws, potentially change the impacts on the small and medium-sized businesses that you guys work with?
Yeah, a federal law would ease the compliance burden that the state patchwork has created by giving small businesses one set of rules to follow without having to then constantly look over their shoulder for new state laws or new amendments lowering thresholds or including new provisions. Again, small businesses want to protect their users' privacy, and it's hugely important to our members that they are able to do so. And a federal preemptive law would make this easier and then let them devote resources to innovation, developing new tools and new products, and serving their customers. And then it would also give their customers, again, much clearer rights that are then easy for them to ask for and talk about with authorities if something were to go wrong.
Jake, anything to add about sort of the benefits of a federal privacy law and federal preemption?
Right. The benefit of preemption is it eliminates some of this conflicting authority as far as what when you talk about things like private right of action versus AG enforcement, or again some of these other highly consequential aspects of these bills. And that's where some of the rub is coming with the proposed federal solution of carving out BIPA, carving out California's law. A lot of those more problematic provisions are contained in those laws that are being floated as being carved out. So hopefully a federal fix would truly harmonize the law, and again, we can figure out, again, there's whether that's the FTC providing some of that enforcement opportunities, and I do think it's important that it be handled in legislation. I think it was a couple years ago, right? The FTC under the previous administration was trying to usurp some of that privacy authority through the rulemaking process. That absolutely should be Congress providing that in legislation. Easier said than done, but it's going to be so important, again, as we're talking about what a national AI framework is going to look like, what's a national kid safety framework going to look like. It doesn't make sense for me to kind of do those two things without also doing privacy, and hopefully do privacy first, not at the, oh, we just forgot to do privacy, now we're going to do that later.
And then Deb, your thoughts on federal preemption and its potential impacts?
I think federal preemption, total federal preemption without carve-outs is really necessary. If you want to have a comprehensive data privacy bill that applies to every single American in the country, the only way to do that is through a complete preemption in the federal law.
Yeah, definitely. To a point that Jake made about easier said than done when it comes to Congress passing a privacy law. Jake, if you want to get started and talk about how this proliferation of state privacy laws has impacted the debate over what a federal privacy law would look like, and particularly our sort of prospects for full federal preemption, like Deb mentioned.
Yeah, so I've kind of hinted at this a couple times so far throughout, but I think the more established some of these state regimes become, unfortunately, that makes it a little bit more difficult to reverse course. Like it or not, Californians are now used to the fact that they have that California notice at the bottom of the page, or they're used to this agency existing, and it's often touted by the governor's office and legislators across as this huge win that states are leading on. And then in the case of Illinois, as I know there's been some tangible impacts where certain features of certain products are just omitted in Illinois, and that also doesn't get a lot of attention. I think it was Shutterfly, I think, was an example where certain features they were threatened with litigation through BIPA, so they just pulled out certain features from Illinois residents. So that's an example of consumers missing out on innovations. Again, doesn't really make sense in kind of this interstate commerce concept that Illinois would have that type of authority to do that. So it is a risk that, if I think under that framework I mentioned from Chairwoman Rogers a couple of years ago, you saw, the California delegation was coming out strongly against the proposal. They were being protective of what their state has done in their view. Unfortunately, and California carries a lot of weight in Congress. They have 50 some odd representatives, so they're going to be highly influential in the discussion. And then another fear that I saw too was that you had, especially as generative AI continues to bubble up, some AI provisions being shoehorned into a privacy bill could also be problematic. We should stay focused on privacy, and then AI completely deserves its own separate attention. Kids' safety as well. To the extent these can be bifurcated and kept separate, let's not insert poison pill amendments. I think there's some good agreement, bipartisan agreement. Another thing that's not mentioned is some of these privacy bills have gone, with broad bipartisan support. So maybe focus on the things in an increasingly polarized world. Let's focus on what we agree on, and then we can use that as a foundation.
Definitely. Deb, your thoughts on kind of how this patchwork impacts federal preemption?
Well, Jake makes a great point that, a lot of the legislators, they want to protect what their states have done. They're there to represent the constituents in their state who elected the state reps to do the things that they're doing. And California, as Jake mentioned, is like the big state. I mean, they do have 50 plus members. So they hold a lot of weight and a lot of voice. And I think that's one of the reasons why it was so difficult to even get any movement last Congress. It was so close. The legislation was so close. And it really came down to preempting state laws and the private right of action piece, which was pretty broad and would have allowed anybody to sue anybody for anything. So when you got those two components in the legislation, it really is a heavy lift to get it moving through Congress. And, you've got members who do want to preempt state laws because they know it's important that we have one national framework to do this. But then, we do have the barrier where we do have a big contingency from states like Illinois. You've got, folk that California is the biggest in Congress. So it's a heavy lift. It's a heavy lift to get this moving through Congress, and we have not even seen draft language this Congress, which is a little disappointing at this point when Congress was just so close last time. And now we have not even seen any legislation pushed forward at all. And we're running out of time, honestly. We're really running out of time in Congress because, in the next few months, members are going to start thinking about what's going to happen in November. They're going to be focused there instead of on, legislation like consumer data privacy. So the clock is ticking, and that's one thing that we all need to keep in mind is that there's not a lot of time left in this Congress to get something done.
Definitely. And Morgan, your thoughts on federal preemption and kind of the optimistic versus more maybe realistic take on it?
Yeah, to echo Deb and Jake, state privacy laws have definitely intensified the preemption debate in Congress, and this growing patchwork has made it harder that, as the more state laws that exist, the harder it's going to become to harmonize them. So the ENC Privacy Working Group very clearly has its work cut out for it, and I do hope that we see an actual bill that establishes, one set of standards for small business to follow soon. And I'm very glad Deb mentioned the private right of action, because it does seem like the debate is often like, preemption in exchange for a private right of action. But a PRA would be devastating for small businesses. It would often prompt kind of sue and settle approaches where small business will have just enough money to pay folks who are kind of, more opportunistic, then it would be to, go and fight something in court, even if it's a very bad faith allegation. So that would be horrible for small businesses, and a private right of action should absolutely not be included in any federal bill that Congress introduces.
Jake or Deb, do you want to further pull on kind of the thread of the private right of action? I know that's kind of more of one of the top two sticking points, like Morgan mentioned, up with federal preemption. Deb, if you would like to speak first.
Well, the private right of action is really a gift horse to the trial attorneys, in my opinion. And that is my opinion, not the opinion necessarily of my employer. But it's kind of like saying, okay, we're opening up a bar to allow lawsuits for anything, regardless of how frivolous it may be. And Morgan made a great point. For a lot of businesses, it comes down to, do we go through the expense of a protracted legal battle, or do we just settle? And in most cases, what will happen is that they end up settling because smaller businesses, small to mid-sized businesses, cannot afford protracted legal battles in court, even over frivolous complaints.
I think that's a great point, Deb, and and that's kind of the logic of having the state AG provide enforcement is that they will field in the request and make that determination. But I could see it really spiraling out of control, especially when it comes to AI as well.
I'm going to very quickly pause our conversation. We're about a little bit more than halfway through, so I just wanted to remind our audience we're starting to get a few of your questions through the Slido, which is great. Just a reminder, we're going to be taking audience questions toward the end. So if you want to get those in maybe the next 10 minutes, we'll shift the conversation to audience questions. But I've got just a few more of my own questions first. I want to zoom out a little bit and talk about this from an international perspective. How does this patchwork impact America's position on a global stage, especially when it comes to things like cross-border data negotiations, the impact, like Jake mentioned, on international companies and businesses that do business off there?
Yeah, so fragmentation makes it harder just overall for the United States to present a clear and unified approach when negotiating cross-border data governance with other countries. And because we don't have, that one approach, businesses operating internationally have to then navigate both global privacy regimes and a very complex set of US state laws, which is, again, just very, very difficult for small business to do and multiplies the impact that compliance obligations will have on them. So a comprehensive federal privacy law would strengthen the U.S. position in both these international discussions and just make it easier for small business to start operating internationally as
Jake,
well.
anything to add on that point?
I do, and interstate and cross-border data, a little bit, out of my wheelhouse. But Alec does actually. We have a vertical that's focused on international relations and digital trade, and our members, recognizing this continues to be an issue. We developed actually a model resolution for state legislators opposing the imposition or expansion of digital trade barriers, making some key points again about how this hindering cross-border data flows. Ultimately, it's small and medium-sized businesses back home that are hurt by those measures. And again, encouraging, there's not a ton that states can do upon themselves when it comes to matter of global trade, but they can put pressure on the administration, to make sure that those kind of strong open data policies and data smart cross-border data policies are in place. So it is something that ALEC members are looking at, even if they don't have too heavy a hand in it directly.
And then Deb, anything to add from your end?
Yeah, when our government goes into negotiation for various trade agreements, digital trade has to be a part of that because we do have a lot of cross-border data flows. And when we don't have one standard for how that data is controlled for privacy, and we're negotiating with a country, say in the EU, which has a very stringent data privacy regime under the GDPR, it really makes it difficult in those negotiations for us to say, you must treat our data a certain way. And they may not agree with it, and they can just point to the fact that we don't have one national law to protect our data as it's flowing across borders. Even within our own country, we don't have that standard. So, it's really important that we do get that national standard because it strengthens our position in negotiations with our foreign counterparts.
Definitely. I'm going to have one more question from me, and then we'll turn our time over to audience questions. We've been kind of sprinkling references to other digital policy debates like AI governance and children's online safety. What hopes or concerns do the three of you have as we see states and Congress turning their attention to these kind of closely related areas? Jake, you've mentioned these a few times if you want to get us started. Oh, Jake? Morgan.
Yeah, so I am very concerned about seeing some fragmentation in areas like AI governance and online safety. A lot of the proposals would make this fragmentation just a lot worse. Online safety proposals such as the App Store Accountability Act directly hurt consumer privacy and security, which would make it incredibly difficult for developers to then protect user data while also trying to comply with new regulatory requirements in every single state that has one of these laws. It essentially takes the state patchwork of privacy laws and then adds another layer on top of it, and then AI governance, another layer on top of that, which is just way too much for business to have to comply with without having to then direct resources away from hiring and innovation, growth, and whatnot. So especially for AI, federal policymakers should learn from the state fragmentation that happened with the privacy patchwork and create clear and harmonized rules before another patchwork forms.
Just want to apologize. Jake is having a few technical difficulties. The consequences of any virtual event, but I love them because we get to talk to people all over the country and the world. Deb, your thoughts on kind of patchworks in AI governance and children's safety and potentially other issues?
Yeah, it's children's online safety needs to be its own mechanism. And it again also should have a more national framework, just simply because these children are online. They are crossing borders. It's again interstate commerce. So again, there needs to be consistent federal laws relating to the privacy of our children. And also along that vein, advanced computing technology like AI, that is something that it's a technology. It's not necessarily data flowing. It's a technology that's being used to implement various processes. But then again, it does require data to be stored. The data is going to be crossing borders. And my thought is that any legislation or any law that's created at a national level relating to consumer data privacy, if that consumer data is being used through AI technology, it would be covered under a comprehensive data privacy bill because it's a technology. It's a means, it's a tool. So are we regulating every single tool that we use, or does this comprehensive data privacy bill cover all the different technology tools that we choose to use? And I think that's like a broader question.
Jake, you've mentioned these debates about AI governance and children's online safety. What are your thoughts on kind of the debates happening at the state level when it comes to these issues?
Yes, so it is entirely consuming state legislatures right now. This focus of AI legislation. Alec just put out a research publication a couple weeks ago documenting the rise in legislation not only being introduced but enacted. So actual laws being put into effect. Back in 2023, we were talking about 100 AI bills. Now I think you've already had around 1,500 bills submitted just this year. So a lot of them carried over from the previous year because that's how state legislatures function. But even if 10% of those bills end up becoming law, you're talking about 100 new AI laws that Morgan's member companies and other, and it's not even just companies. Even some of Colorado's anti-bias and discrimination law, you had like University of Colorado all of a sudden was like, whoa, are we affected by this? Or do we have to do a risk assessment if we're going to implement this? So it's much far reaching than, again, even if legislators are looking at some of the hyperscalers or, OpenAI, Anthropic, Google, it goes so much more than that. And some of these definitions, are not great. I'll just put it bluntly about what's considered AI or what's considered autonomous. And you're sweeping in basic functions and tools like Grammarly or, Excel spreadsheets or just YouTube's algorithm. So legislators really need to hone in, and Alec provides some of that as far as model policy on AI solutions. But to Deb's point, data privacy could at least help solve some of these problems, especially when it comes to the kids issue as well.
Definitely. All right. I will turn to audience questions now. Again, don't forget you could drop your questions by following the Slido link. Should be available in the event description, no matter where you're watching this. We've got a great audience question here that I think has fit right in with some of the conversation topics that we've brought up. And I want to start with Jake again on this one. Is there a current state privacy law, or, I'll add provisions in certain state privacy laws that you think are a potential model for a national framework?
I've mentioned the Virginia approach from about 5 years ago a few times. That one does seem to be pretty good. It's more of that notice and consent model. Could it be improved? Absolutely. But it could be a great starting place for some national negotiations. That's what I would recommend. It does get a bit more difficult though. Even if a state wants to port it over entirely, a lot of times, each state has little quirks, and so they are inherently going to be different in some ways. So I wouldn't say that a 50 state privacy bills isn't really a substitute for a federal unified framework. So it's certainly better than having a like mutually exclusive framework like I was talking about before. But if you have to, if you're a legislature and you have to pursue it, that's what I would recommend.
Morgan, any thoughts on these state laws emerging that might be better than other ones, or provisions in those laws that you think are particularly good?
Yeah, I would very much echo Jake here. We think the Virginia model provides a good place to start. Overall, our recommendation to federal policymakers has been to use the 4 Ps of privacy. So that's no private right of action, protection against unauthorized access, so protection against potential hacks, a path to compliance, such as a safe harbor and a right to cure, and then preemption in a federal model to make sure that small businesses have one set of rules to follow to protect their customers' data.
And then Deb, your thoughts on kind of the better provisions in these state laws?
Yeah, again, looking at the Virginia model, the consent model is, really a good model to follow. And, if Congress can take a look at states like Virginia and others that have reasonable statutes in place and draw from, let's just call it the best of the good. Let's pull the best from the good, and put together a national framework that gives consumers the protections that they want and they need, does not overly burden businesses so that they cannot compete in the marketplace, and just allow for the flow of data to occur, but in a protected environment. That is the best path forward, I think. And like I said, Congress came very close to doing something last Congress, but those 2 items, the private right of action and the state exemptions from being preempted, really created a barrier to finally passing a national framework.
Another audience question, speaking of lessons learned or lessons that could be learned, are there any good or bad takeaways that the US could pull from other countries' approaches or the EU's approach with its GDPR? Deb, do you want to start us with that one?
Sure. Well, it seems like the GDPR, the EU is already looking at it and going, oh my gosh, what did we do to our economy? And they're starting to pull back some of those provisions that were particularly heavy handed on their own businesses and their own industries. The EU really likes to regulate the US, but they forget often that they have companies in their own countries that want to do much the same thing that we do here in the US. So they're already starting to pull back some of those provisions, not all of them, and it's going to take time to pull back. But we are all flooded right now with the clicking out. Yes, I know I'm getting cookies. Yes, I know I'm getting that my data is going to be used in certain ways, and all these pop-up boxes that are just now starting to appear here in the US. That's been happening since the GDPR was enacted in the EU over in Europe. And they're frustrated over there because they get so many pop-up boxes saying, here's how your data is going to be used, when all they want to do is just go to the website and do what they want to do on the website and then be done with it. So, when you over-regulate, it really creates barriers to commerce. It creates barriers to communication. It just really creates havoc on the whole ecosystem and on the economy.
Yeah, and barriers to efficiency as well. Not to plug one of ITIF's reports, but I'm going to. We have kind of looked at the potential impacts of GDPR-like regulation if we pass that in the US, and there is definitely an impact just in lost time for consumers clicking through these cookie banners and notices that most of us, I'll be frank, I don't read them. I'm not taking that kind of time out of my day. And I know most people don't. Morgan, what are your thoughts and sort of the thoughts of the businesses that you represent and work with on the GDPR?
Yeah, so our members were really glad to see some of the changes that were initially proposed in the digital omnibus to try and make compliance with the GDPR easier to balance with innovation. It appears that they've since pulled some of those back, like the definition of personal data that was changing, which is disappointing to see. So I think the biggest lesson that policymakers in the United States can take from what's going on over in the EU is that innovation and consumer protection must be balanced. And in order to remain a global leader in technology, in order to make it easier for business to compete and to innovate and to grow, we do need to make sure that the regulatory environment supports that instead of just completely hindering it and blocking it.
Yeah, Jake, you're anything to add there?
I just wanted to emphasize something that Deb said that is important because I'll slightly disagree as far as the EU legislators love GDPR, the businesses, not so much. And in fact, the legislators are almost accelerating with, as far as laws like the Digital Services Act and Digital Markets Act are now fully phased in more or less at this point. People often forget too that I think it was Italy, the nation of Italy back in 2023 banned ChatGPT temporarily through GDPR, through a privacy, mechanism. So there is some kind of maybe some unintended consequences or perhaps intended consequences of, using a law like this to regulate a lot more than just privacy in some situations. So that's just something I wanted to flag as well. And, especially with some services like, for instance, Google, a lot of the value add from using Google's suite of products is that they, exchange information with each other. And then some of these, these provisions in the DSA and the DMA would prohibit, Google Maps from talking to Gmail, from talking to Google Search. And that can, limit the utility that a lot of, it's not the company that's saying that, it's the users, that love that connectivity. And that's what they see as the value.
Definitely, yeah. Continuing to talk about this from an international perspective and using the GDPR as a comparison, because in many ways it did kick off a lot of the country by country discussion when it comes to comprehensive privacy regulation. We've mentioned that, one of the factors kind of influencing states to pass their own privacy laws is obviously that there isn't a federal privacy law in the US. And so that federal inaction in many ways has created a vacuum that a lot of states have felt a duty to fill or a desire to fill. And there is just plenty of opportunity there. Is there what are potentially the pros or drawbacks of a framework like what Jake mentioned? If we had 50 different, mostly similar privacy laws in the different states, again, probably not very likely, but imagine that it was, versus federal privacy law that was maybe stricter than a lot of businesses and consumers would benefit from, or than you guys would think would be positive for innovation. Is it worth passing basically a federal privacy law if it's going to take a too strict approach or too burdensome approach like the GDPR? Morgan, thoughts on that from a business perspective?
Yeah, so I think as the laboratories of democracy, the state experimentation within the patchwork has surfaced some really great provisions, such as consumer rights concerning their data that Congress should definitely include in a federal version. However, in crafting that federal version, they should definitely avoid being too heavy-handed. As a global leader in technology, it is very important that Congress balance consumer protection with innovation in a federal law. Second, while the experimentation within states did produce some really useful insights that Congress should definitely take, they should make sure to also avoid, some of the lessons that laws like the GDPR have offered when it comes to maybe not being so great for innovation.
Jake, your thoughts on this potential patchwork versus federal approach?
Yes, I mean, one advantage to the patchwork approach, if I had to pick an advantage, is that the damage can be kind of localized. So I mentioned that Illinois they were missing out on some features and products. That present, that's more or less limited to Illinois residents, which it's not great if you're an Illinois resident, but at least there's some tangible data and results that we can evaluate as policy experts and as legislators and legislator staff. We have different case studies, if you will, of this is what Oklahoma's been able to do, and this is what Illinois has done, and this is what New York's done. And then hopefully, like Morgan said, then that kind of percolates up the chain. But yeah, I do fear that if, a lot of what these companies want at the end of the day, whether it's a technology company or a retailer, or a service provider, they want some sort of consistency, and they want to know what the rules of the road are. They don't want to know that they're operating with 50 different sets of rules, or that the rules are going to ping pong every 4 years just because there's a new president. So hopefully Congress can resolve this issue once and for all. And again, it can serve as a cornerstone foundation, show that there can be an alternative to GDPR, or with some of the other more strict laws across the globe. The U.S. has that inherent advantage. We have the innovation base. Frankly, consumers and users also, they can demonstrate that privacy is important to them. I know there's some research has borne out that people may say they like privacy, but then their choices reflect something different. So that's also a balance, essentially, is what can lawmakers do to protect consumers while still reflecting their intent and their choice.
Deb, your thoughts?
Yeah, I agree with both Morgan and Jake on this. I think, for a national framework to really provide the protections that are needed, we do need to look at what the states are doing well and draw from the state laws to put together a good comprehensive standard that will satisfy consumers, help businesses grow, and protect our data from harm. That's ultimately what this whole conversation is about, is how do we best protect our data from unintended or intended harm.
We've only got a few minutes left in the conversation, and I want to give each you kind of a chance to wrap up the arguments you've been making, the opinions you've been sharing, and the experiences that you've brought with you. We mentioned at the top how this state privacy patchwork and the federal privacy debate has played a role in your work, in your organization's work. I want to go to each of you and ask if you could give one kind of main takeaway for listeners, for policymakers, when it comes to this state patchwork and the potential for federal preemption. What would that takeaway be? Morgan?
Yeah, small businesses want to protect their consumers' privacy, and establishing one federal preemptive standard will help them do so and make it easier for them to do so alongside innovating, hiring, growing, and continuing to serve their customers. So it's imperative that Congress pass a model that does so and establishes one single standard setting.
Deb, your kind of main takeaway that you would give?
Sure. I would say, again, having one national standard will provide the certainty that businesses, consumers across the country can use to have that, protection that they're wanting, protection that they've been asking for, and it will be a consistent standard that will be easy for small, medium, and large businesses all to follow and comply with without undue burdens or cost associated with compliance. That'll help our economy in the long run grow and thrive.
And then Jake, your final thoughts, main argument that you would make?
Final thought is, like it or not, states are not going to slow down. They're going to keep going. All the more important that we don't lose the momentum on a federal bill. Let's learn the lessons. And meanwhile, groups like ALEC and other state-based organizations are going to focus on how lawmakers can build workable policies that meaningfully protect consumers, give consumers ability to control their data, and provide better services, but still work for that federal standard.
I want to thank all three of you for joining me in this conversation today. I think we covered a lot of ground. I'm really happy to have heard your different perspectives that you've brought from your years of work in in this sort of policy field and working on privacy from different angles. I also want to thank our audience for tuning in. If you want to send this event to other people who weren't able to tune in live, no matter where you watched it, you should be able to send the video on demand version. You can also find our 3 panelists online through their different organizations. Their bios will be on our website on the event page if you want to learn more about them and what they do. And if you want to tune into more of ITIF's events, again, you can subscribe to our YouTube channel, follow us on LinkedIn, or follow us on Facebook, or subscribe to our newsletter. You've got a lot of different options. Again, I want to thank everybody for joining, for being here. And that'll be a wrap on today's event.